Okay. We shall be starting the event. Can you please close the door? Can you please close the door? I would like to thank you all for coming to this second moot court event, which is a collaboration between Dentistry and Law Schools. We are very honored today. We have our rector, our vice rector here, and the director of Dental Services of Cyprus. And I would call our rector to give a welcome.
Good afternoon, everyone. It's a pleasure to welcome you all to this second moot court in dental practice, which follows the event which was carried out last year. I personally heard very nice words about this activity, which combines activity from two of our schools, the School of Law and the School of Dentistry. And actually, Professor Cavadia was partly rewarded for this activity in the teaching awards, excellence in teaching, only yesterday. So I'm personally looking forward to this activity because I couldn't attend it last year. And so without any further ado, let's proceed with the second moot court in dental practice. Thank you.
This joint educational activity serves not only as an innovative learning method, but also as a meaningful opportunity for interprofessional education and collaboration between our two schools. This project-based initiative allows students, under the guidance of the professors, to actively participate in a simulated courtroom trial addressing issues related to dental traumatic injuries and to professional liability in dentistry. The case centers around an alleged injury sustained during a basketball game, highlighting the legal and ethical responsibilities of dental practitioners. Through this experience, our students gain invaluable insight into dental legal frameworks and courtroom procedures. More importantly, they develop critical thinking, problem solving, communication, and teamwork skills, essential competencies for their future careers as professionals. This event is held under the academic guidance of Dr. Charalambos Tamelos, Assistant Professor at the Law School, Dr. Mary Kaliva and Konstantina Taufik, lecturers in School of Dentistry, Dr. Olga Trifonos, Scientific Collaborator, School of Dentistry, Dr. Athina Moraiti, Scientific Collaborator, School of Education, Humanities and Social Sciences, and myself. Furthermore, the event was supported by our scientific collaborators, Professor Djoudzas, Drs. Petropoulou, Lambrou, Soloukidou, and Kesaris, all collaborators at the Dentistry School. On behalf of all of us, the supervisors, we extend our warmest congratulations to all participating students. Your commitment, diligence, efforts, and teamwork, often outside of regular academic hours, have been truly commendable. And Dr. Stamelos now will address on behalf of the law school.
Thank you. Dear colleagues and guests, it is a great pleasure to welcome you to this second moot court in dental practice. This year we said dental practice, last year we said dental malpractice, and there is a reason for this, you will see. Over the past 12 months, I have had the honor of coordinating this event alongside Professor Katerini Cavadia and the other collaborators. And Professor Cavadia, as you know, she received the prestigious award. Congratulations, Professor Cavadia. Together, we brought 20 students of dentistry and 30 students from the law school. Our aim is to encourage collaboration and build valuable interprofessional skills. This moot court is the result of their, hard work, teamwork, and enthusiasm. We are excited to share it with you today, May 20, 2025. Thank you for your attendance.
Today's case will be deliberated by a three-judge moot court composed of a panel of 50 enthusiastic students. We hope that you, the audience, will find today's event as engaging and enriching as we did during these 12 months of preparations. The event will run in two parts for about a total of 2 hours duration, with a brief break in midway. Additionally, you, the audience, will have twice the opportunity to vote via Poll Everywhere, digital polling, on the liability of the parties involved. And now let the court session begin.
So this case pertains to a 15-year-old patient, Haralambous George from Athens, who suffered dental trauma during an international school basketball tournament in Rome. In the basketball court, there were 2 referees, 1 tournament physician responsible for the good health of all participants in the tournament, 2 more physicians, 1 for each team, the 2 coaches who were also responsible for providing first aid in case of emergency, 2 physiotherapists, and 2 trainers. The game started even though the tournament physician had not arrived in court. In fact, he had called the referee informing him that he was parking his car and arriving in 2 minutes. So when the plaintiff and the defendant were in position for jump ball, the defendant, Pablo Montero, pushed the plaintiff so aggressively that his front teeth avulsed. The trauma resulted in the avulsion of teeth 11 and 21. The teeth were not replanted and no tooth saver kit was available at the basketball court. Thus, the avulsed teeth were preserved in a gauze by the coach of the team until the patient was taken to a local hospital 3 hours later with his parents. There, a non-call dentist reimplanted the teeth and applied a non-flexible splint, as it was the only type of splint available at the hospital. The dentist claims that he informed the patient's parents to seek further dental care immediately upon their return to Greece for radiographic evaluation and to begin endodontic treatment. However, the parents claimed they were not given clear instructions or a referral note. No hospital dental discharge report exists either. The patient then returned to Athens with his team. The patient, already undergoing orthodontic treatment prior to the accident, visited his orthodontist in Athens 2 months upon his return for a follow-up visit. The orthodontist adjusted the arch wires and referred the patient for dental trauma follow-up to his pediatric dentist. The pediatric dentist in Athens examined the patient 3 months after the injury, removed the splint, and upon taking an X-ray, noticed signs of resorption in teeth 11 and 21, and therefore referred the patient to an endodontist for further care. However, the family relocated to Cyprus and delayed the visit to the endodontist.
Two months after the relocation to Cyprus, the patient visited the endodontist and began endodontic therapy with calcium hydroxide as an inter-appointment medicament. After 2 months with calcium hydroxide, findings indicated that the resorption had become inactive and the teeth were asymptomatic. As a result, the endodontist proceeded with the obturation of the root canals with epoxy resin-based sealer in combination with gutaperca. During the periodontist's evaluation, it was confirmed that teeth 11 and 21 had no mobility and no deep periodontal pockets were detected, indicating relative stability. Future treatment plans include monitoring teeth 11 and 21 for potential root canal failure and/or root resorption, which may ultimately result in tooth loss and the need for prosthetic rehabilitation. Furthermore, alveolar growth should be assessed to evaluate the risk of intrapositioning in the upper anterior region. Needless to say that an athletic mouthguard must be conducted to prevent further sports-related trauma in the future.
In light of the above, the 15-year-old parents are filing an action before the court to demand damages. They are turning against all the persons and stakeholders involved. What is important to stress is this. The tournament physician was not present at the time of the accident. In fact, he had called the referee, Mr. Johnson, saying he was parking his car and would arrive in 2 minutes. Despite this, the referee, Mr. Johnson, went ahead and started the game. So, what legal measures are being taken? First, the family, both parents and the child, are filing a lawsuit for damages, and they are turning against everyone involved: the opposing player, the referees, the coaches, the teams, the medical staff, and the tournament organizers.
Why? Because all these people had the duty to protect the players' safety, and collectively they failed. First, the tournament physician, who was officially responsible for the health and safety of all participants, was absent. Starting the match without him was a serious breach of duty. Second, the referees, despite knowing the physician was not there, allowed the game to start. This shows clear negligence.
Third, the team coaches, who were also responsible for first aid, failed to stop the match or delayed until medical assistance was on site. And of course, there is the individual player whose excessive and aggressive push caused the injury. Under tort law, both Greek and Italian, such a violent act during a game can create personal liability. Beyond that, there is also vicarious liability. The executives and coaching staff of the teams and the tournament organizing authorities may be held responsible for the actions of people under their supervision.
The family is claiming damages for the medical costs, including emergency dental treatment, ongoing care, and the likely future expenses of reconstructive work, as well as compensation for the moral suffering of their child. To conclude, ladies and gentlemen, this case is not just about one aggressive move during a game. It's about a chain of wrong decisions and negligence that led to a serious and lasting injury. An injury that could have been prevented if basic safety protocols had been respected. Thank you. The hearing starts.
Docket number 1. The first case is the case of A versus B. Is Miss A here? Miss A? Not present. Is Mr. B here? Not present. This case is cancelled. Now we turn into case 2. Docket number 2. The second case is the case of Mr. Haralambous and all versus Pablo Montero, in total 11 defendants. Is Ms. Andrea Haralambous here?
Yes, Your Honor. She is represented by advocates Neofotistou and me, Nicolaidou.
Is Mr. Haralambous the patient's father here?
Yes, Your Honor. He is represented by advocates Neofotistou and me, Nicolaidou.
Is Mr. Pablo Montero the actor's father here?
Yes, Your Honor. He is represented by me, Patakias, and by attorney Arapadonis.
So, Ms. Andrea Haralambous is not here, but is represented by the attorneys Neofotistou and Nicolaidou. George is not here, but he's also represented by the attorneys Neofotistou and Nicolaidou. And Pablo Montero, the actor, is not present as well, and is represented by the attorneys Patakias and Arapadonis.
Is defendant number 2, Mr. Johnson, the referee here?
Yes, Your Honor. Mr. Johnson, the referee, is present, represented by me, Attorney Jeffrew.
So, Mr. Johnson is here and he is represented by the attorney Jeffrew. Is the defendant number 3, Dr. Green, the doctor of the game, here?
Yes, Your Honor. Dr. Green, doctor of the game, is present, represented by me, Attorney Trabas.
So, Dr. Green, defendant number 3, doctor of the game, is here and he is represented by the attorney Trabas. Is the defendant's number 4, organizing authority, legal representative, here?
Yes, Your Honour, the legal team representing the organising authority is present and it's been represented by me, Attorney Barras. Thank you.
So, defendant number 4, organizing authority, is represented by the attorney Barras.
Is the defendant number 5, Coach Mr. Ioannou, the doctor of Team A, Dr. Panayotou, here?
Coach Ioannou and the doctor of Team A, Dr. Panayotou, is present, represented by me, Attorney Tartis. Team A is represented as well by me.
So, defendant number 5, Dr. Panayotou, doctor of the Team A, is here, represented by the Attorney Tartis, and Team A is represented by Attorney Tartis. Is the defendant number 6, Team B, and Mr. Brown, doctor of Team B, here?
Mr. Brown, doctor of Team B, is present, represented by Attorney Mako. Team B is represented as well by me.
So, defendant number 6, Mr. Brown, doctor of the Team B, is here, represented by Attorney Mako, and Team B is represented by Attorney Mako. Is the defendant number 7, Dr. Spalletti, dentist in Rome, here?
Defendant number 7, Dr. Spalletti, dentist in Rome, is present and represented by me, Attorney Xentopoulou.
So, defendant number 7, Dr. Spalletti, dentist in Rome, is present and is represented by the attorney Xenitopoulou. Is the defendant number 8, Dr. Dimitriou, orthodontist in Athens, here?
Yes, Your Honor. Defendant number 8, Dr. Dimitriou, orthodontist in Athens, is present and represented by me, Attorney Zagoti.
So, defendant number 8, Dr. Dimitriou, orthodontist in Athens, is present and is represented by the attorney Zagoti. Is the defendant number 9, Dr. Nicolaou, pediatric dentist in Athens, here?
Yes, Your Honor. Defendant number 9, Dr. Nicolaou, pediatric dentist in Athens, is present and is represented by me, Attorney Mr. Bernaba.
So, defendant number 9, Dr. Nicolaou, pediatric dentist in Athens, is present and is represented by the attorney Bernaba.
Is the defendant number 10, Dr. Petru, endodontist in Cyprus, here?
Yes, Your Honor. Defendant number 10, Dr. Petru, endodontist in Cyprus, is present and is represented by me, Attorney Nofitidis.
So, defendant number 10, Dr. Petru, endodontist in Cyprus, is present and is represented by the attorney Nofitidis.
Is the defendant number 11, periodontist in Cyprus, here?
Yes, Your Honor. Defendant number 11, Dr. Ioannou, periodontist in Cyprus, is present and represented by me, Attorney Kalaizaki.
So, defendant number 11, Mr. Ioannou, periodontist in Cyprus, is here and is represented by the attorney Kalaizaki. Do you have any witnesses or any expert witnesses? Yes, Your Honor. Very well. Please approach the bench and produce us the relevant documents.
Now we go on with the opening statement of the attorneys of the plaintiff, Ms. Neofotistou and Ms. Nicolaidou. You may start.
Your Honor, esteemed members of the court, today we stand before seeking justice for a young boy who has endured not only physical pain, but also emotional distress, all due to the reckless and negligent actions of those who were entrusted with his safety. This case is about accountability. It is about ensuring that those responsible for his suffering do not evade the consequences of their actions. On the day of the incident, my client, a dedicated young athlete, stepped onto the basketball court believing that he was in a safe and regulated environment. He had no reason to expect that he would leave that court with 2 of his front teeth violently avulsed, facing oral disability, with years of painful and costly dental treatments. Yet, that is exactly what happened. The defendant, in an act of reckless aggression, forcefully pushed my client during the opening jump ball, causing an injury so severe that his teeth were completely dislodged from their sockets.
Unfortunately, the mother and the child are not present today due to emotional distress. Allow me to present the facts of this case. My client, a 15-year-old patient from Athens, suffered dental trauma during an international school basketball tournament in Rome, resulting in the avulsion of teeth 11 and 21.
Kindly, could you be more specific about that?
Two upper central incisors.
Thank you.
Teeth were picked up from the ground, however, were not replanted. Since no tooth saver kit was available at the basketball court, the avulsed teeth were preserved in gauze until the patient was taken to a local hospital 3 hours later. There, an on-call dentist replanted the teeth and applied a non-flexible splint as it was the only splint available at the hospital. My clients were not given clear instructions or a referral note after being discharged. Our client was already undergoing orthodontic treatment prior to the accident. He visited his orthodontist 2 months later in Athens for a routine follow-up visit. During the visit, the orthodontist adjusted the orthodontic wires and referred the patient to a pediatric dentist for further care. My client went to his pediatric dentist, Ms. Nicolaou, 1 month later, who diagnosed resorption of teeth 11 and 21 and referred to the endodontist for further treatment. However, before visiting the endodontist, the family relocated to Cyprus, causing a 2-month delay in starting endodontic treatment. Once in Cyprus, the 15-year-old began endodontic therapy. The endodontist referred the patient to a periodontist. During the periodontist evaluation, it was confirmed that teeth 11 and 21 had no mobility and no deep periodontal pockets were detected, indicating relative tooth stability. The evidence will show that my client's injuries were not merely the result of an unfortunate accident. They were the direct and foreseeable result of multiple failures that could have been avoided had each party fulfilled their respective duties. The reckless conduct of the defendant, the negligence of the referee and event organizers, the inadequacies of the emergency treatment provided in the hospital, all these factors compounded the harm my client has suffered and will continue to suffer in the years to come. The teeth 11 and 21 survival over my client's lifetime is also questionable. We seek for damages and emotional distress for reparation. Thank you.
Thank you. Councillor Patakias and Arabandonis, please proceed with your opening statement for the defendant, Pablo Montero.
Your Honor, today we stand before this court to present the defense of the minor who is accused of causing injury to the plaintiff during a basketball tournament. While we fully recognize the unfortunate circumstances surrounding the plaintiff's injury, we respectfully submit that the incident in question was an unfortunate accident, not the result of reckless or intentional conduct by our client. Basketball is, by its very nature, a contact sport where players engage in physical interaction, especially during critical moments such as the opening jump ball. The incident occurred in the normal course of play without any intention to cause harm. It is important to highlight that our client acted in the heat of the game, attempting to gain possession of the ball, a standard and expected action in the sport. There is no evidence to suggest that his actions were motivated by aggression, malice, or disregard for the safety of others. Moreover, we must emphasize that the rules of basketball allow for incidental contact, and such contact does not automatically translate into reckless or negligent behavior. The incident in question took place within seconds of the game starting, making highly unlikely that our client could have planned or intended any harm.
Your Honor, the burden of proof rests within the plaintiffs to demonstrate that our client's actions amounted to recklessness. However, there is no clear evidence to support such claim. The tournament was organized and supervised by the school authorities, who bear the responsibility of ensuring that proper safety protocols, including the availability of medical and dental kits and adequate first aid measures, were in place. the absence of tooth implantation of a tooth saver kit and the subsequent delay of emergency medical dental care cannot be attributed to our client. Furthermore, the defendant is a minor, participating in a school-organized activity and should not be held solely accountable for an unforeseeable accident. In conclusion, we respectfully request that this court dismiss the claim against our client, as there is no evidence of reckless or negligent behavior. Thank you.
Thank you. Councillor Jeffriou, please proceed with your opening statement for the defendant number 2, Mr. Johnson.
Your Honor, I stand before you today representing the referee, the second defendant in this case. The facts of this case are undoubtedly distressing, and we express our sincere sympathy for the pain and discomfort the plaintiff has endured. However, it is our position that the plaintiff acted within the scope of his professional duties and cannot be held liable for the injuries sustained by the plaintiff. The role of the referee in any sporting event is to oversee the game, ensure the rules are applied fairly, and maintain the safety of the participants to the best of their ability. It is important to emphasize that the referee is neither a medical professional nor a health supervisor. In this case, while it is regrettable that the doctor had not yet arrived at the court, there is no regulation or formal guideline that stipulates a referee must delay the start of a match in such circumstances. The defendant acted in accordance with common practice and the tournament schedule, which indicated that the match should proceed at the designed time. Furthermore, the incident that caused the plaintiff's injury was a result of the actions of another player, not the referee. The referee could not have reasonably foreseen that the defendant player's push would result in such a severe dental injury. It is neither the referee's duty nor within their ability to prevent every accidental injury that may arise during the course of the game. Finally, no causal link can be established the referee's decision to commence the game and the plaintiff's dental injury. The accident was unforeseeable, and the referee fulfilled his duties within the limits of his role. For these reasons, we respectfully request that the court dismiss the claim against the referee, as there is no basis for assigning liability to my client. Thank you.
Thank you. Councillor Trabas, please proceed with your opening statement for the defendant number 3, Dr. Green.
Your Honor, while the absence of the doctor at the start of the game is regrettable, there is no direct evidence to suggest that my client's presence would have prevented the plaintiff's injury. The doctor's primary obligation is to provide medical care once an injury has occurred, and the delay in treatment was due to circumstances beyond their immediate control. Furthermore, the doctor's actions upon arrival were in accordance with the available resources at the time, which included preserving the teeth in gauze and arranging for hospital transportation. Moreover, the lack of clear instructions to the plaintiff's parents was not intentional, but rather a result of the chaotic nature of emergency situations. Therefore, my client acted in good faith and to the best of his professional ability under the given circumstances and bears no liability. Thank you.
Councillor Barras, please proceed with your opening statement for the defendant number 4, the organizing authority.
Thank you, Your Honour. On behalf of the organising authority, we wish to express our deep regret for the unfortunate injury of the plaintiff. However, it is our position that the organising authority fulfilled its obligations to the best of its ability in accordance with the applicable safety protocols and cannot be held liable for the plaintiff's injury. The organising authority's role was to provide the necessary logistical arrangements for the tournament, including securing the venue, scheduling medical personnel, and ensuring that the general safety guidelines were communicated to all participants and their respective teams. The absence of the doctor at the start of the game, while regrettable, was not a direct result of any negligence by the organising authority. The organising authority has properly scheduled medical coverage for the event and reasonably relied on the medical commitment of the medical personnel to be present as agreed, to which, and I cannot emphasise that enough, they were not. Furthermore, the organising authority was not responsible for first aid provisions, such as the tooth saver kit, but the teams were. Thus, any delay in the immediate medical response should not be attributed to the organising authority, but rather to the relevant professionals tasked with delivering emergency care. Therefore, we respectfully request that the court dismiss any claims against my client. Thank you.
Councillor Dartis, please proceed with your opening statement for the defendant number 5, Coach Mr. Ioannou, and the doctor of Team A, Dr. Panagiotou.
Your Honour, we respectfully believe that both the coach and the team doctor acted in accordance with your duties and the standards of care expected of them during the tournament. The coach's primary responsibility was to supervise the players and ensure their participation in the game, while the doctor was present to provide medical care in the event of injury. Neither party had the authority to delay the game due to the absence of the tournament doctor, as this decision rested solely with the organising authority and the referee. Regarding the immediate medical response, the coach acted promptly by preserving the avulsed teeth in gauze, a widely accepted method when no tooth saver kit is available. The team doctor provided care to the best of their ability under the circumstances and arranged for the plaintiff to be transported to the hospital without undue delay. Any shortcomings in the treatment or follow-up care are attributable to the medical personnel at the hospital, not the coach or the team doctor. Therefore, we respectfully request that the court dismiss any claims against the coach and the doctor of Team A, as they acted in good faith and in the best interests of the plaintiff. Thank you.
Councillor Maku, please proceed with your opening statement for the defendant number 6, Mr. Brown, doctor of Team B.
The Team B and its medical staff exercise all reasonable measures to ensure the safety and well-being of all participants during the tournament. The defendant's team coach was responsible for managing their own players and had no authority to intervene in the conduct of the opposing team or the referee's decision to start the match. It was only in the first second of the match when the injury happened, and our player had no intention of harming the opponent. Our coach was vigilant from the first second and throughout the game. He relied on the tournament's medical infrastructure for any health emergencies. He, of course, could not predict such an accident. The team's doctor was available at the medical station, prepared to respond to any injury involving our team's players. The doctor's role did not extend to the plaintiffs, as the injured player belongs to the opposing team. Any delays or shortcomings in the initial medical response were beyond the doctor's scope of responsibility. Therefore, the Team B and the doctor of the defendants cannot be held liable from the injuries sustained by the plaintiff, as he acted diligently and within the limits of their responsibility.
Thank you. Councillor Xenitopoulou, please proceed with your opening statement for defendant number 7, Dr. Spalletti, dentist in Rome.
I, Advocate Xenitopoulou, the defendant's lawyer, after thorough observation and study of the facts of the case, state that the allegations against my client, the treating dentist in Rome, are not only unfounded, but fail to acknowledge the realities of the emergency circumstances in which he had to act. When the plaintiff arrived at the hospital 3 hours after the injury, my client, Dr. Spalletti, took immediate action to save the avulsed teeth by splinting the teeth with a rigid wire. He used only available splinting material at the time, and as he will testify, advised the parents to seek further treatment as soon as possible. The dentist, Dr. Spalletti, faced a severe case of trauma and, with the agreement of the parents, undertook the treatment. Any complications that arose were not due to negligence, but rather to circumstances beyond his control, including delays in follow-up treatment and relocation to another country. My client acted in good faith and within the standard of care given the resources available. The plaintiff's ongoing dental issues are unfortunate, but responsibility for them does not rest with my client, as he adhered to all generally accepted and applicable rules of dental science. We ask that the court consider the full context of the case and dismiss the claims against him. The expert witness affirms the excellent work of my client and is certain that there was no dental malpractice, emphasizing my client's significant contribution to saving the teeth. Thank you.
Thank you. Councillor Zagotti, please proceed with your opening statement for the defendant number 8.
Your Honor, before I start with my opening statement, I would like to respectfully submit this request for the exception of the president of this court from presiding over the present case. It has come to my attention that Judge Armenaka has a conflict of interest, given that she has a personal interest that could affect her impartiality. In the interest of safeguarding the principles of impartiality, fairness, and the proper administration of justice, we respectfully ask the court to exempt Judge Armenaka from this case to prevent any appearance of bias.
We have decided to accept Mrs. Zagoti's request for exception, and this is why we will step down of the bench.
Councillor Zagoti, proceed with your opening statement for the defendant number 8.
Your Honor, on behalf of the orthodontist in Athens, we express our sympathy for the plaintiff's injury and the subsequent challenges faced by the family. However, it is our position that my client acted in accordance with the highest standards of care upon examining the plaintiff and provided treatment within the limits of their specialization. The orthodontist was unaware of the trauma until 2 months post-trauma when the patient visited his office. The orthodontist's primary duty was to assess the condition of the fixed appliances and release all injured teeth from active orthodontic forces. She further made a referral to the patient's pediatric dentist for immediate management of the case, with specific concerns for the removal of the splint and diagnosis for the teeth 11 and 21. Furthermore, the time lapse between the initial injury and the plaintiff's visit to the orthodontist in Athens significantly impacted the prognosis of the affected teeth. Any deterioration in the plaintiff's dental condition was not a result of the orthodontist's actions, but rather the consequence of a delayed follow-up to the pediatric dentist and the endodontist. The orthodontist provided clear and timely instructions and facilitated the necessary referral, thereby fulfilling their professional obligations. Consequently, we respectfully request that the court dismiss the claim against the orthodontist in Athens, as no negligence or breach of duty can be established. Thank you.
Thank you. Now, Councillor Bernaba, please proceed with your opening statement for the defendant number 9, Dr. Nicolaou.
Your Honor, on behalf of Dr. Nicolaou, the pediatric dentist in Athens, we express our deepest concern for the plaintiff's ongoing dental issues. However, it is our firm position that the pediatric dentist acted with the utmost professionalism and care. Upon the plaintiff's visit to the pediatric dentist, a thorough clinical and radiographic examination was conducted, consistent with the standard protocols for dental trauma follow-up, setting the diagnosis of resorption. The pediatric dentist removed the splint and provided the plaintiff's parents with clear instructions on the importance of ongoing endodontic treatment and referred the patient to an orthodontist for further management. Dr. Nicolaou, my client, cannot be held accountable for any previous delays or inadequate care provided. Therefore, we respectfully request that the Honorable Court dismiss the claim against the pediatric dentist, Dr. Nicolaou, as he fulfilled his duties competently and in line with accepted dental practices. Thank you.
Councillor Neofitidis, please proceed with your opening statement for defender number 10.
Your Honor, on behalf of the endodontists in Cyprus, we express our regret for the plaintiff's prolonged dental issues. My client, the endodontist, acted in full compliance with professional protocols. Upon referral, the endodontist performed a comprehensive clinical and radiographic evaluation of the affected teeth, confirming the resorption diagnosis and initiating endodontic therapy without delay. The treatment plan was explained to the plaintiff's parents along with the inherent risks associated with the complex nature of traumatic dental injuries. The endodontist diligently followed up on the patient's progress and advised the parents to continue with regular dental reviews. Any adverse outcomes were the result of the initial trauma and subsequent delays in earlier interventions, not the endodontist's care. Therefore, the endodontist cannot be held liable as all appropriate measures were taken in accordance with standard dental practice. Thank you.
Councillor Kalaizaki, please proceed with your opening statement for the defendant number 11, Dr. Ioannou.
Your Honor, on behalf of the periodontists in Cyprus, we acknowledge the difficulties experienced by the plaintiff. The periodontist's role was limited to assessing the condition of the supporting tissues around the reimplanting teeth and providing specialized periodontal treatment as necessary. The periodontist performed a thorough examination, including radiographic evaluation, to assess the extent of the periodontal damage and provided appropriate treatment to preserve the remaining periodontal structures. The plaintiff's periodontal condition was the result of the initial trauma and subsequent delays in treatment, not any failure of the part of the periodontist. The periodontist provided expert care and appropriate instruction on maintaining oral hygiene to support the plaintiff's recovery. We respectfully request that the court dismiss the claim against the periodontist as he acted in accordance with the standard of care and within his professional remit. Thank you.
We have now completed with the lawyer's statements, and we will start with the witness statements. Witness for the plaintiff, Mrs. Cosma. Witnesses and expert witnesses for the plaintiff and the defendant, please leave the room. Please approach the bench. Will you take an oath?
Yes.
A religious oath?
Yes.
A Christian religious oath?
Yes.
Please put your right hand on the Holy Bible and repeat after me. I swear to tell the truth, the whole truth, and nothing but the truth.
I swear to tell the truth, the whole truth, and nothing but the truth.
Please proceed.
My name is Cosma. I'm the witness of the plaintiff, and I am a family friend of the 15-year-old patient from the father's side. With the patient's father, we have been friends for years. As a result, to know in detail the suffering that my friend's son suffered all this time. I was present at the basketball court on the day of the incident. I recall that the referee insisted on starting the game despite the fact that no medical personnel had arrived. When the jump ball was about to take place, I saw the defendant push Haralambous with excessive voice, causing him to fall. I immediately noticed that he was in significant pain, and upon closer inspection, I saw his front teeth had been completely knocked out. There was visible blood, and it was clear that this was a serious injury. In my opinion...
Objection, Your Honor. No opinions.
Objection sustained. Only the expert witness may express his or her opinion. The witness shall remain on facts only.
Unfortunately, there was no proper first aid equipment available, nor was there a tooth saver kit. The avulsed teeth were placed in a piece of dry gauze, which, as I later learned, was not an appropriate way to preserve them. It took approximately 3 hours before Haralambous could receive treatment at the local hospital. At the hospital, I overheard a conversation when the dentist mentioned the need for further dental care upon the return to Greece. However, from my understanding, no detailed written instruction or formal referral were provided to the parents. I remember the parents being quite distressed, and it would have been difficult for them to fully grasp the importance of seeking immediate follow-up care based solely on a verbal explanation. I remained in contact with the family after they returned to Greece. They were unaware of the extent of the injury's long-term implications until the child's pediatric dentist notice signed of resorptions months later. However, by then, further delays had occurred due to their relocation to Cyprus, which I believe further complicated the situation. The family has been consistently diligent in seeking the best care possible for their child, and it is heartbreaking to see them face the long-term consequences of this unfortunate incident. The family is also very anxious for the long-term survival of their child's teeth. I believe those responsible for ensuring the child's well-being must be held accountable for their actions or omissions. Thank you.
Thank you. You are now excused.
Witness for the defendant, the dentist at the Hospital of Rome. Please approach the bench. Will you take an oath?
Yes.
A religious oath?
Yes.
A Christian religious oath?
Yes.
Please put your right hand on the Holy Bible and repeat after me. I swear to tell the truth, the whole truth, and nothing but the truth.
I swear to tell the truth, the whole truth, and nothing but the truth.
Please proceed.
As a long-time patient of Dr. Spalletti, I can attest to his professionalism and commitment to patient care. Throughout my years of treatment under his care, he has always been meticulous in providing clear instructions, explaining procedures, and ensuring that I understood any necessary follow-up actions. His reputation for thoroughness and attention to detail is well known among his patients, and I have personally experienced his dedication to providing the best possible dental care. During my visits, Dr. Spalletti has consistently demonstrated a high level of expertise. I have never encountered any issues with his treatment or post-care instructions, as he has always made sure that I was fully informed of any next steps required for my dental health. Given my personal experience, I find it difficult to believe that he would fail to provide crucial information to any patient, as thorough communication is a hallmark of his practice. In conclusion, the dentist has consistently delivered excellent medical care over the past 4 years. I have always found him to be professional and meticulous in their approach to dentistry. Thank you.
Thank you. You are now excused.
Now we are inviting you, the audience, to vote. If you scan this QR code, and according to your opinion, who is more liable? It's a ranking poll system. Students, please register with your names. It's going to be attendance for you this way, and all other guests, you don't need to register if you don't like. And I will just open now the poll. Is it working? The results after the intermission. It's going to be a 15 minutes break, and we'll have you all back in 15 minutes. For part 2 of the corner, and then you can vote for this first part and see who do you vote as more liable. You cannot? Okay. Can you scan this now? Αυτό δεν το μπορώ. Okay, now I'm going to the question. You can rank. Who do you think is more liable here? So still live, still moving. Okay, so we vote coaches and doctors more liable, and actor, okay, dentist least liable. Okay, we're gonna vote again after we finish the second part with the expert witnesses, and then we'll see if you've changed. Okay, let's move now to the next one. Okay. So the board starts.
The defendant's expert witness for the dentist in Rome, Dr. Michaela Stupi, please approach the bench. Will you take an oath?
Yes, I'm willing to take an oath.
A religious oath?
Yes, Your Honor.
A Christian religious oath?
Yes, in accordance with my faith and beliefs.
Please put your right hand on the Holy Bible and repeat after me. I swear to tell the truth, the whole truth, and nothing but the truth.
I swear to tell the truth, the whole truth, and nothing but the truth.
Please proceed.
I stand before you today as an expert witness to provide a professional opinion regarding the dental care provided to the patient in Rome after a basketball-related dental injury. First and foremost, it is essential to highlight that the dental avulsion is a severe injury, requiring immediate and appropriate intervention to maximize the chances of successful reimplantation and long-term tooth survival. Based on the information provided, as well as given the circumstances, the dentist followed the standard international protocols.
Dr. Stupi, can you explain to us the measures taken by the attending dentists?
Of course. Despite the 3-hour delay, the dentist reimplanted and splinted the avulsed teeth, prioritizing the preservation of the patient's natural dentition. A non-flexible wire splint was A non-flexible splint was used due to limited materials, which is common in emergency settings, while the damaged orthodontic wires were adjusted to prevent further injury. Moreover, the dentist verbally instructed the patient's parents to seek dental care in Greece, as follow-up treatment is standard for avulsed teeth. Such guidance is standard practice, as long-term management of avulsed teeth typically requires follow-up endodontic treatment and radiographic monitoring. While a written report is not provided, it does not necessarily indicate a breach of duty or negligence. In many emergency settings, verbal instructions are often used for aftercare.
Considering your expertise, how have the actions of the defendant affected the prognosis of the injured teeth?
It is important to emphasize that the success of dental avulsion treatment depends on 3 parameters: the dry time, the storage, and the follow-up care. The delay in endodontic treatment, the relocation upon return to Greece, and finally to Cyprus may have worsened root resorption. In conclusion, the dentist in Rome provided appropriate emergency care. The lack of immediate implantation, the absence of tooth saver kit, and the delayed hospital visit were beyond the dentist's protocol. The reimplantation procedure and the post-operative advice, even if delivered verbally, align with standard emergency dental protocols, making any adverse outcomes a result of multiple external factors. Thank you.
Thank you. You are now excused. We now call the expert witness against the dentist in Rome, Dr. Christoforos Pavlou. Please approach the bench. Will you take an oath?
Yes.
A Christian religious oath?
Yes.
Please put your right hand on the Holy Bible and repeat after me. I swear to tell the truth, the whole truth, and nothing but the truth.
I swear to tell the truth, the whole truth, and nothing but the truth.
Please proceed.
I am Christoforos Pavlou, a dentist with 10 years of experience in practicing, and specifically an extensive experience in dental trauma management. Your Honor, I am here today as an expert witness to provide a professional opinion on the standard protocol for managing dental aversion injuries and to assess the measures undertaken in this particular case. My expertise is based on extensive experience in dental trauma management, adherence to international clinical guidelines, and a thorough review of the facts surrounding this incident.
Can you please elaborate on the actions taken by the attending dentist?
Well, upon arrival of the kid at the hospital, the attending dentist did not adhere to the established clinical protocol. The teeth were reimplanted but secured with a non-flexible splint rather than a flexible one, such as fishing line, which is contrary to best practices. The orthodontic brackets along with a flexible orthodontic arch wire could have been used for splinting as an easier and more appropriate method. Additionally, the dentist did not assess the patient's tetanus vaccination status or recommend a booster, did not prescribe antibiotics to prevent infection and inflammatory resorption, and failed to take radiographs to confirm proper positioning post-reimplantation. There was not even proper photographic documentation, which is standard procedure in this case.
Would you like to explain which actions indicated by standard practices were not taken?
Well, first, there's no written report whether neurological evaluation was performed to rule out brain injury, since this may occur in such dentofacial injuries. Moreover, considering the patient was treated abroad of his home country, clear and detailed written instructions should have been provided for follow-up care in their home country. The lack of such documentation contributed to further delays and miscommunication upon the patient's return that resulted in significant delay in seeking crucial follow-up care by the parents. Namely, the correct follow-up care is the initial endodontic intervention, but it should have been commenced within 10 days post-splinting. The splint itself should have been removed between 2 to 4 weeks after placement. As a result, the patient did not visit an endodontist until 5 months after the injury.
How, in your opinion, may this delay have affected the case outcome?
Well, the significant delay contributed to complications such as infection of the periapical tissues, progressive root resorption, and increased risk of eventual tooth loss.
What is your conclusion as an expert regarding the actions taken by the hospital dentist?
My conclusions are that the failure to adhere to standard clinical protocols in the initial treatment phase significantly compromised the patient's prognosis. Had the appropriate emergency measures been implemented promptly, the likelihood of successful long-term outcome would have been substantially higher. Instead, the delays and incorrect interventions led to unnecessary complications, prolonged treatment, doubtful survival of the teeth, and increased financial and emotional burden on the patient and his family. The dentist at the time of the emergency intervention failed to follow the appropriate scientific guidelines, resulting in unnecessary harm to the patient. As an expert witness, I can confidently state that the adherence to standard trauma protocols would have greatly improved the prognosis of the avulsed teeth.
You are now excused.
Dr. Daniel Carney, please approach the bench. Will you take an oath?
Your Honor, I'll take a civil oath.
Please repeat after me. I solemnly declare on my honor and conscience that I will tell the whole truth and nothing but the truth, without adding or concealing anything.
I solemnly declare on my honor and conscience that I will tell the whole truth and nothing but the truth. without adding or concealing anything.
Do you believe that the orthodontist is to blame for mismanagement of this case?
Your Honor, I, Dr. Daniel Carney, declare that the orthodontist did not mismanage this case. I have been working with orthodontists for the past 15 years as an associate, and I can assure the court that he always provides the best treatment for his patients. We managed the case together when the patient came to our office for this routine orthodontic follow-up. However, during the appointment, the orthodontist was first notified about the trauma. At that visit, the orthodontist adjusted all orthodontic appliances in the maxilla as not to exert any forces to the traumatized teeth. He further made a referral to the patient's pediatric dentist, informing the parents of the need of immediate management of the trauma case, with specific concerns of removal of the splint and diagnosis for teeth 11 and 21.
Could you tell us why the orthodontist did not remove the splint and the orthodontic appliance to minimize the risk of complications?
Yes, Your Honor, that's a good question.
Please, no comment. Please proceed.
Sorry. Radiographic examination of injured teeth, as well as stability of reimplanted teeth, has been checked first before removal of the splint. This was necessary to verify that injured teeth did not have excessive mobility. It's important to mention that removal of the splint should be done by the pediatric dentist. Thus, the orthodontist strongly recommended immediate referral to the patient's pediatric dentist.
In your expert opinion, did the orthodontist's actions align with standard care protocols?
Yes, Your Honor. The orthodontist acted according to the best practice guidelines and his experience, since evidence-based standard care protocol unfortunately does not exist for such orthodontic cases. As for the treatment, he adjusted the fixed orthodontic appliances by not exerting any active force to the injured teeth. Orthodontic treatment shall continue to all teeth except for the injured ones. Any forces to the injured teeth should be avoided for at least 1 year, since they may result in additional root resorption. As we all know, is a complication dramatically affecting the survival of these important front teeth. Regarding the long-term outcome of orthodontic treatment, there are not enough specific case studies and reviews published in literature to support the orthodontic management of teeth that have sustained avulsion. Hence, specific guidelines of how to treat these cases cannot be provided, and treatment is given as practitioners deem best.
Thank you. You are now excused.
The expert witness against the orthodontist Kauri Augustsson, please approach the bench. Will you take an oath?
Yes.
A religious oath?
Your Honor, I will take a civil oath.
Okay, please repeat after me. I solemnly declare on my honor and conscience that I will tell the whole truth and nothing but the truth without adding or concealing anything.
I solemnly declare on my honor and conscience that I will tell the whole truth and nothing but the truth without adding or concealing anything.
Do you believe that the orthodontist acted as appropriate? Please proceed.
The orthodontist should be blamed for not removing the splint. Furthermore, the parents were not informed about the urgency of the referral to the pediatric dentist in relation to the follow-up of the injury. Regarding the orthodontic treatment, he failed to explain to the parents that long-term consequences of such trauma may result to compromised tooth alignment of the injured teeth.
Okay, but why will the alignment of the teeth be compromised?
The alignment may be compromised because active orthodontic forces cannot be applied to the traumatized teeth. If we apply orthodontic forces to these teeth, there's a heightened risk of root resorption of the involved teeth.
But since the parent did not visit the pediatric dentist in a timely manner as they were advised, how is the orthodontist to be blamed?
The orthodontist had to inform the parents about the urgency of the situation and ought to explain again the need to see a pediatric dentist. I suggest that the orthodontist ought to book an appointment at the pediatric dentist to make sure that his patient receives the best treatment.
So you suggest that when the orthodontist makes recommendations to his patients, he needs to verify whether his recommendations are being followed. Probably it would require all of his working time to do so.
It is obvious to all the court participants that avulsion cases are not the same as everyday treatment recommendations. Hence, the follow-up had to be closely monitored by the orthodontist.
Thank you. You are now excused. The expert witness for the defendant pediatric dentist in Athens, Dr. Kari Irana Gusson, please approach the bench. Will you take an oath?
Yes.
A religious oath?
Your Honor, I will take a civil oath.
Please repeat after me. I solemnly declare on my honor and conscience that I will tell the whole truth and nothing but the truth, without adding or concealing anything.
I solemnly declare on my honor and conscience that I will tell the whole truth and nothing but the truth without adding or concealing anything.
Please proceed.
Your Honor, I, Kaurihapn Augustsson, a board-certified pediatric dentist with extensive clinical experience to dental trauma, I am here to affirm that the pediatric dentist in this case adhered rigorously to accepted standards of care and made clinically sound decisions within the constraints created by prior mismanagement. My analysis is grounded on the tooth avulsion guidelines of the International Association of Dental Traumatology that are also endorsed by the American Academy of Pediatric Dentistry and the documented timeline of this case.
What were the exact steps the pediatric dentist took?
The steps that the pediatric dentist took were the following: a detailed history of the trauma, thorough clinical examination, radiographic evaluation, removal of the splint, checking of tooth mobility and tooth vitality testing. Upon removal of the splint, Your Honor, teeth 1-1 and 2-1 had no mobility. The findings of this case were slight discomfort upon chewing, negative cold and electric pulse testing, and significant radiographic external root resorption for both teeth. A diagnosis of inflammatory root resorption due to non-vital 1-1 and 2-1 is thus suggested. Based on this diagnosis, the pediatric dentist recommended the following follow-up care: referral to the endodontist for immediate endodontic management to halt the inflammatory resorption and complete the root canal treatment, adhering to the International Association of Dental Traumatology guidelines in order to save the teeth. You may download these guidelines if you can, if you scan the QR code on the screen. To avoid further complications in the future, the pediatric dentist instructed the patient to return for long-term follow-up and for the fabrication of an athletic mouthguard for prevention of further trauma. A customized mouthguard was previously recommended to the patient, but was never fabricated since the parents did not request it.
In your expert opinion, did the pediatric dentist's actions aligned with standard care protocols?
Yes, the pediatric dentist's approach was consistent with the established guidelines. The pediatric dentist removed the splint and emphasized the need for immediate endodontic management to halt the inflammatory resorption.
Thank you. You are now excused. The expert witness against the pediatric dentist, Dr. Daniel Carney, please approach the bench. Will you take an oath?
Yes, Your Honor.
A religious oath?
I will take a civil oath.
Please repeat after me. I solemnly declare on my honor and conscience that I will tell the whole truth and nothing but the truth, without adding or concealing anything.
I solemnly declare on my honor and conscience that I will tell the whole truth and nothing but the truth, without adding or concealing anything.
Do you believe that the pediatric dentist is to be blamed for this case? Please proceed.
Your Honor, in my opinion, the pediatric dentist should be held responsible for not performing a more thorough radiographic examination.
What do you mean? Please elaborate.
Yes, Your Honor. Cone beam computer tomography, also known as a CBCT, is a three-dimensional radiographic imaging technique that gives the most accurate finding for bone and teeth in oral and maxillofacial trauma. By taking a CBCT, we can assess the exact location and extent of root resorption for affected teeth. Furthermore, the urgency to visit the endodontist for pulpal management was not clearly communicated to the parents.
Would the treatment of 2111 change if a CBCT existed?
Your Honor, perhaps not, but more information would exist regarding the complications.
Do you believe that the avulsions of the teeth could have been prevented?
Your Honor, if the pediatric dentist had advocated more intensely for the fabrication of athletic mouthguard for his patient, as he plays basketball, which is a very high-risk sport for dental injuries, before the injury occurred, that would have probably prevented the avulsion of the teeth. Of course, provided the patient would be wearing it throughout the basketball game.
Thank you. You are now excused.
The expert witness for the defendant, the orthodontist, Dr. Petalas, please approach the bench. Will you take an oath?
Yes.
A religious oath?
Yes, Your Honor.
A Christian religious oath?
Yes, in accordance with my faith and beliefs.
Please put your right hand on the Holy Bible and repeat after me. I swear to tell the truth, the whole truth, and nothing but the truth.
I swear to tell the truth, the whole truth, and nothing but the truth.
Please proceed.
Your Honor, as a board-certified endodontist with over 15 years of clinical and academic experience, I am here to affirm that in this case, the endodontists adhere rigorously to accepted standards of care and made clinically sound decisions within the constraints created by prior mismanagement. My analysis is grounded in the European Society of Endodontology guidelines, the International Association of Dental Traumatology protocols, and the documented timeline of this case.
Dr. Petalas, can you elaborate on the timeline of the events after the incident?
Well, the endodontist encountered this case 5 months post-injury, after clinical errors had already irreversibly compromised the teeth prognosis, which are avulsed teeth were not reimplanted on site and were stored in dry gauze for 3 hours, causing periodontal cell death. A non-flexible splint was left in place for 3 months versus the 2 to 4 weeks, which is maximum recommended. No endodontic treatment or follow-up radiographs were performed for 5 months. By the time the endodontist assumed care, the teeth exhibited advanced inflammatory root resorption and infection, conditions directly attributable to the initial mismanagement.
In your expert opinion, did the endodontist's actions align with the standard protocol?
I can assure the court that the endodontist had adhered to currently recommended protocols. Firstly, the placement of calcium hydroxide. The use of calcium hydroxide as an inter-appointment medicament was appropriate and evidence-based. Calcium hydroxide is the gold standard for disinfecting root canals and halting inflammatory resorption, even in delayed reimplantation cases. Peer-reviewed studies confirm its efficacy in stabilizing teeth with advanced pathology. Secondly, the use of approved obturation materials. The endodontist followed the American Association of Endodontists guidelines by utilizing biocompatible materials for root canal obturation. These materials are designed to seal the canal system and minimize reinfection, which is critical in trauma cases with compromised prognosis. Third, the structured follow-up protocol. The endodontist instituted a clinically appropriate monitoring schedule, including radiographic and clinical evaluations, to track the healing and the resorption. This aligns with International Association of Dental Traumatology recommendations for long-term management of traumatized teeth. Fourth, we have the collaboration with the periodontist. The endodontist coordinated with care with the periodontist to address periodontal health and occlusal stability, ensuring a multidisciplinary approach to mitigate further complications.
In your expert opinion, how do the actions of the endodontist align with the contemporary best practices?
Well, regarding the timing of endodontic intervention, while the ideal endodontic treatment occurs within 7 to 10 days of injury, the endodontist faces a patient present 5 months post-injury with established infection and resorption. In such cases, the priority shifts to halting disease progression rather than achieving ideal outcomes. The endodontist acted promptly upon assuming care, which is the standard for delayed presentations.
And how did he document the disease progress?
Well, the endodontist used two-dimensional radiographs and not CBCT, which was reasonable here. CBCT is not routinely required unless complex anatomy or ambiguous pathology exists. The resorbed lesions were evident in 2D imaging, and CBCT would not have altered the treatment plan.
Did the endodontist inform the family of the prognosis of the teeth?
The endodontist's obligation was to treat the pathology presented and not to revisit prior providers' failures. The patient was advised of the tooth-guarded prognosis due to the delayed presentation, as documented in the protocols.
Do you believe that the results would have been different if the endodontist had acted differently? Could he act differently?
Had the endodontist deviated from the above protocols, for example by extracting the tooth immediately or skipping calcium hydroxide therapy, he would have violated the duty to attempt salvage. The teeth, while compromised, retained functional and aesthetic value for the patient. The endodontist actions extended the teeth usability, buying time for the patient and family to plan future care, for example, placement of implants.
As an expert, what is your conclusion regarding to the endodontist's actions?
Your Honor, the endodontist in this case practiced in alignment with evidence-based guidelines. The adverse outcomes, like root resorption, infection, and eventually tooth loss, are likely due to the initial mismanagement and delays, not the endodontist actions. In fact, the endodontist interventions mitigated harm and provided the patient with the best possible chance of retention under the circumstances. To hold the endodontist responsible for consequences originated from prior negligence would set a dangerous precedent, punishing providers who intervene to salvage complex cases. I urge the court to recognize that the endodontist adhered to the standard of care and acted in the patient's best interest.
Thank you, you're excused. The expert witness, Dr. Jason Alas, please approach the bench. Will you take an oath?
Yes.
A religious oath?
I will take a civil oath, Your Honor.
Repeat after me. I solemnly declare on my honor and conscience
I solemnly declare on my honor and conscience
that I will tell the whole truth
that I will tell the whole truth
and nothing but the truth
and nothing but the truth
without adding or concealing anything.
without adding or concealing anything. I, Dr. Jason Allen, am fit to be the expert witness against the defendant, the endodontist in Cyprus, as I've been practicing excellency in endodontics for 20 years. I've studied the evidence thoroughly and prepared the following report. Your Honor, while the initial mismanagement set the stage for complications, the endodontist's actions, or lack thereof, constituted an additional deviation from the standard of care, directly contributing to the adverse outcome. I can identify causes of liability consistent with the records.
Can you elaborate more on these facts, Dr. Allen?
Yes, Your Honor. As the endodontist saw the patient 5 months post-injury, which was well beyond the critical 7 to 10 day window, therefore root resorption and infection were inevitable. However, the endodontist proceeded with the standard calcium hydroxide therapy without modification, when the clinical guidelines emphasize, in cases of delayed treatment, different obturation materials are warranted. For example, mineral trioxide aggregate or bioceramics. By adhering to the protocol designed for early intervention, the endodontist failed to mitigate an already poor prognosis, potentially accelerating tooth loss.
In your opinion, were there any measurements that the defendant could have taken to avoid future complications?
In my opinion, yes. The endodontist relied solely on two-dimensional radiographs. There was no CBCT or advanced imaging to assess the extent of the root resorption and concomitant ankylosis. This oversight violated modern standards, as 2D imaging lacks sensitivity for detecting early resorption. Also, the patient and family were not adequately informed of the decreased success rate of treatment due to the 5-month delay.
This cannot be the endodontist's fault, as the patient visited him 5 months after the incident.
True, Your Honor. The endodontist did see the patient 5 months post-trauma. However, the endodontist failed to communicate the severity of the situation to them. This deprived the patient and the family the opportunity to make an informed decision, which violates both ethical and legal obligations. Also, the endodontist failed to communicate with colleagues for systemic risks. There's no documentation of communication with the orthodontist nor the pedodontist. This fragmented communication may contribute to resorption or infection to go unchecked.
Can you explain how things could be monitored?
The standard of care for such trauma would include 2, 4, and 8 week and 3, 6, and 12 months follow-up and yearly and every year thereafter. Instead, the patient was left without clear guidance, risking delayed recognition of failure and missed opportunity for intervention.
Based on all this, what is your final conclusion?
Your Honor, while initial mismanagement created challenges, the endodontist's failure to adapt treatment to the delayed presentation, to obtain informed consent, and to coordinate interdisciplinary care all may have transformed a straightforward case into a potential failure. These omissions represent a cause of the patient's harm independent of prior mistreatment.
Thank you. You are now excused. We now call the expert witness for the periodontist in Cyprus, Alice Angelopoulos. Please approach the bench. Will you take an oath?
Yes, Your Honor.
A religious oath?
Your Honor, I will take a civil oath.
Please repeat after me. I solemnly declare on my honor and conscience that I will tell the whole truth and nothing but the truth, without adding or concealing anything.
I solemnly declare on my honor and conscience that I will tell the truth, the whole truth, and nothing but the truth without adding or concealing anything.
Please proceed.
I am Dr. Alice Angelopoulos, specialist in periodontics, and I report that based on the records, the periodontist conducted a comprehensive periodontal examination. Findings indicated stable periodontal health with no signs of pathology. A follow-up plan was established in line with the International Association of Dental Traumatology guidelines.
Can you describe the steps the periodontist took during the patient's appointment?
Based on the records provided, the periodontist performed a thorough clinical examination, including periodontal probing to assess pocket depth, bleeding on probing, evaluated tooth mobility, and reviewed radiographs to monitor the root integrity and alveolar bone level.
What were the results of this assessment?
According to the records provided, the examination revealed no periodontal pockets, no bleeding gums, no tooth mobility or signs of infection. Radiographic analysis showed intact bone level, indicating there were no signs of periodontal disease. The already diagnosed external root resorption was confirmed.
What follow-up care did the periodontist recommend?
Based on the records, the schedule of regular monitoring was established to detect future changes, particularly focusing on the need for performing decoronation due to the future infrapositioning of the involved teeth, adhering to the International Association of Dental Traumatology guidelines.
In your expert opinion, did the periodontist's actions align with the standard care protocols?
Yes, the periodontist's approach was consistent with established guidelines, emphasizing careful monitoring without unnecessary interventions.
Thank you. You're now excused.
We now call the expert witness against the periodontist to take the floor and testify. Dr. Cleopatra Papapetru, please approach the bench. Will you take an oath?
Yes.
A religious oath?
Yes, Your Honor.
A Christian religious oath?
Yes.
Please put your right hand on the Holy Bible and repeat after me. I swear to tell the truth, the whole truth, and nothing but the truth.
I swear to tell the truth, the whole truth, and nothing but the truth.
Please proceed.
Your Honor, I, Dr. Cleopatra Papapetru, specialist in periodontics, I am here today to declare some alternative treatments that could have been carried out. My professional opinion on my colleague's approach on how dental trauma was handled is that systemic antibiotics could have been prescribed as adjunct treatment. While their efficacy in preventing root resorption is not well established, some clinicians consider them to potentially reduce bacterial contamination, which might influence resorption processes.
What about surgical interventions?
Regenerative surgery using enamel matrix derivative, EMD, could have been performed. This treatment contains proteins that may promote periodontal tissue regeneration, potentially aiding in preventing root resorption.
Is there another procedure that could have been considered?
Yes, immediate decoronation, which involves removing the crown of the tooth in order to preserve the alveolar bone, could have been considered as a preventive measure against some future complications.
In your opinion, did the periodontist take all possible steps to prevent further issues?
Your Honor, my opinion is that by not implementing any of the additional measures mentioned, the periodontist may have missed opportunities to enhance a more promising long-term prognosis of the patient's teeth.
Thank you, Dr. Papapetru. You may be excused.
We now call the expert witness against the basketball tournament organizers to take the floor and testify. Athina Dzadzaki, please approach the bench. Will you take an oath?
Yes.
A Christian oath? A Christian religious oath?
Yes, Your Honor.
Please put your right hand on the Holy Bible and repeat after me. I swear to tell the truth, the whole truth, and nothing but the truth.
I swear to tell the truth, the whole truth, and nothing but the truth.
Please proceed. Dr. Dzadzaki, what is your expert opinion regarding the tournament organization? Was it appropriately prepared?
I am Athina Dzadzaki, an emergency medicine specialist. As a licensed emergency medicine physician with 12 years of experience, including trauma care in sports settings, I can state the following regarding the international school basketball tournament in Rome and the incident involving the plaintiff. On the day of the incident, several critical failures in the response to the plaintiff's injury can be noted. At first, lack of mouthguard recommendation. At no point before or during the game were players advised to wear athletic mouthguards, despite basketball being a high-contact sport with well-documented risks of dental trauma. This omission represents a blatant violation for standard preventive protocols.
Any other observations?
Except that absence of on-site dental expertise. While 2 team physicians and a tournament physician were present, there was no dentist or dental professional available to manage the avulsion. Immediate replantation is time-sensitive and requires specialized knowledge. Without this expertise, the coaches and medical staff resorted to storing the teeth in dry gauze, a suboptimal method that jeopardized the long-term retention of the teeth. What else we noticed was the failure to replant immediately. The avulsed teeth, 11 and 21, were not replanted at the scene, contrary to international guidelines recommended immediate replantation. The coaches, though well-intentioned, lacked training in dental first aid. This delay significantly reduced the chances of successful outcome.
Anything else?
No access to storage media. A tooth-saving kit, such as Hank's balanced salt solution, was missing, or even cold milk was unavailable. dry storage in gauze accelerates cell death in the periodontal ligament, directly contributing to the resorption observed later.
Can you clarify how the delayed response and lack of proper dental first aid directly impacted the plaintiff's long-term prognosis?
The plaintiff was not transported to a hospital for 3 hours. In dental avulsion cases, the critical window for replantation is 60 minutes or even less. This delay, compounded by improper storage, rendered the eventual replantation far less effective. Hence, standard protocols been followed, meaning mouthguards mandated a dental professional on site, immediate replantation or use of proper storage media, and timely hospital transfer, the plaintiff's teeth would likely have been retained without minimal complications. Instead, the combination of neglect and delay led to irreversible root resorption, necessitating thus complex endodontic therapy, lifelong dental monitoring, and a reduced chance for long-term retention of the teeth.
What is your conclusion regarding the above?
The psychological and financial burden on the plaintiff and his family could have been mitigated without basic preventive and acute care measures. The tournament organizers failed to ensure adequate safety measures, including mouthguard policies and on-site dental preparedness. The medical team's inability to act decisively, coupled with the referee's decision to start the game without confirmed medical readiness, reflects systemic negligence. These lapses directly exacerbated the severity of the plaintiff's injury.
Thank you, you're now excused.
Now we go with the final expert witnesses for the actions taken by the general dentist in Rome. Dr. Marina Pepou, please approach the bench. Will you take an oath?
Yes.
A religious oath?
Yes.
A Christian religious oath?
Yes, Your Honor.
Please, put your right hand on the Holy Bible and repeat after me. I swear to tell the truth, the whole truth, and nothing but the truth.
I swear to tell the truth, the whole truth, and nothing but the truth.
Can you please inform us about your professional and education background?
I am Galia Pepou, graduate of Dental School, European University Cyprus, with 13 years of clinical experience managing dental trauma in a practice dedicated to acute dental injury care. As a certified member of the International Association of Dental Traumatology, my expertise in post-avulsion protocols, informed by hundreds of cases, establishes my qualifications to assess the standard of care in this matter.
Please proceed. What, in your opinion, is the primary cause of the adverse consequences following the incident?
Your Honor and members of the court, although failure to properly manage the case in the basketball court as soon as the incident occurred, namely to reimplant the teeth immediately or store them in an appropriate storage medium and have a dentist reimplant them within 1 hour, reduced the tooth survival probability from more than 90 to less than 30%, mistakes in subsequent management further complicated the treatment outcomes.
Can you elaborate more on this? Which steps of subsequent management cause these complications?
The use of a non-flexible splint is contraindicated in avulsion cases as it promotes ankylosis and resorption. Omission of critical steps included no prescription of antibiotics, tetanus assessment, radiographs, or photographs.
Any other actions that may have caused a poorer prognosis for the injured teeth?
Yes, Your Honor. No written instructions were given, failing to provide guidance for follow-up care abroad, leading to fragmented treatment. These actions constitute a deviation from the standard of care, directly causing irreversible periodontal ligament cell death and infection.
What is your final conclusion?
My expert opinion is that the general dentist did not adhere to best practices, causing further complications in the long term that could have been avoided had he acted differently.
Thank you. You are now excused. Now we go with the final expert witness for the actions taken by the orthodontist. Dr. Dimitriadou, please approach the bench. Will you take an oath?
Yes.
A Christian religious oath?
Yes.
Please put your right hand on the Holy Bible and repeat after me. I swear to tell the truth, the whole truth, and nothing but the truth.
I swear to tell the truth, the whole truth, and nothing but the truth.
Please proceed. Dr. Dimitriou, can you please inform us about your professional and education background?
I've been working as an orthodontist for the last 20 years. For the last 10 consultants of the Department of Emergency Dental Care at the University Dental Clinic in Vienna for the orthodontic management after dental trauma.
Will you say that you have a lot of experience in dental trauma and orthodontic management?
I'm a member of an interdisciplinary team who has treated more than 1,000 cases over the years. So you could say that I'm experienced. And don't forget that I'm also a member of the research team that studies the orthodontic management of avulsed teeth.
Could you tell us if the orthodontist ought to remove the splint when he saw the patients 2 months after the trauma?
No. The correct management was to refer the patient for proper evaluation by trained for trauma dentists.
Can you explain to us why, as mentioned by previous experts, the orthodontist ought to remove the splint at that appointment?
Without having a periapical X-ray, it's not possible to make a diagnosis on the condition of the tooth and evaluate if it will be better to conduct the endodontic treatment under splinting of the teeth. And do not forget, without an X-ray, you cannot be certain for the trauma type, so removing the splint with no X-ray will be considered as malpractice.
Could you clarify the last sentence?
I can. Without an X-ray, you cannot exclude the possibility of a root fracture that requires 4 months splinting time, and the parents had no discharge paper from the hospital to be certain about the type of trauma.
Could you please tell us whether the orthodontist ought to see the child early and not 2 months after the trauma?
It depends. If it was to see the patient in order to proceed with the orthodontic treatment of the upper teeth, or to evaluate the avulsed teeth, the answer is no. The orthodontist, when asked for trauma management advice, he ought to refer the patient to dentists trained to treat such cases, such as the pediatric dentist or the general dentist. And in fact, he did refer the patient to the pediatric dentist.
But shouldn't the orthodontist see him for the orthodontic treatment?
To tell you the truth, no. Since avoiding orthodontic treatment for 1 year improves the prognosis and minimizes the complications.
But in our case, complication occurred. Should he not see him earlier, or should he suspect it?
An avulsed tooth in dry environment for 3 hours will most probably present replacement resorption, so he ought to know that complications could occur and have alternative treatment plan for such case.
Do you think that even after seeing the patient, he did not take the proper actions?
Well, the orthodontist let the other specialties do their job. The only thing he could do was to remove orthodontic forces from the traumatized teeth until the trauma dental management was finished. And I did not say that he did not take the proper actions.
So, the orthodontist should have done nothing.
I did not say that. He ought to communicate with the other specialists to coordinate treatment as long as the parents gave their consent.
Do you believe that the prognosis of the orthodontist treatment is affected by the way he acted?
Please bear in mind that for orthodontic treatment after avulsion, there are not specific guidelines, but only some published case report articles that have investigated the subject. Each trauma is a unique case, so you have probabilities, but not certainties about the outcomes, especially in a case like that, where there were so many delays in the management that can all negatively affect the prognosis. The prognosis of orthodontic treatment is affected by trauma management and teeth prognosis,
Thank you.
And not by the orthodontist.
Thank you. You are now excused. Now on, we go with the final expert witnesses for the actions taken by the pediatric dentist.
The court-appointed expert witness, Dr. Maria Gugnarudi, please approach the bench. Will you take an oath?
Yes.
a religious oath?
Yes.
A Christian religious oath?
Yes, Your Honor.
Please put your right hand on the Holy Bible and repeat after me. I swear to tell the truth,
I swear to tell the truth,
the whole truth,
the whole truth,
but nothing but the truth.
but nothing but the truth.
Please proceed.
Your Honor, members of the court, the pediatric dentist initiated the proper history assessment, clinical and radiographical evaluation, removed the splint, and referred the patient to the endodontist for further treatment as per the best practices warrant. Therefore, my expert opinion is that the actions taken by the pediatric dentist adhere to the current best practices, limiting further complications and increase the chances of extended survival of the avals teeth of the athlete.
If the pediatric dentist had taken a cone beam X-ray, would it have changed the outcome of the treatment of the prognosis for this patient?
It probably would not have changed the outcome, but the parents might have realized the aggressiveness of the injury and the urgency to visit immediately the endodontist.
Thank you, Dr. Gouniaroudi.
Now we go on with the final expert witness, Dr. Christina Peru, for the actions taken by the periodontist. Please approach the bench. Will you take an oath?
Yes, I'm willing to take an oath.
A religious oath?
Yes.
A Christian religious oath?
Yes, Your Honor.
Please put your right hand on the Holy Bible and repeat after me. I swear to tell the truth, the whole truth, and nothing but the truth.
I swear to tell the truth, the whole truth, and nothing but the truth.
Please proceed.
Your Honor, members of the court, the periodontist who managed the case conducted thorough periodontal evaluation. Furthermore, he referred the case for further endodontic assessment and treatment and implementing a long-term monitoring plan to track resorption and infraposition risks. Therefore, I conclude that this specialist adhered to guidelines and mitigated further harm. According to my expert opinion, he acted as indicated and provided the patient with the highest standard of care.
Thank you. You are now excused.
Now we go with the final expert witnesses for the actions taken by the orthodontist. Dr. Tsayani, please approach the bench. Will you take an oath?
Yes.
A religious oath?
Yes.
A Christian religious oath?
Yes.
Please put your right hand on the Holy Bible and repeat after me. I swear to tell the truth, the whole truth, and nothing but the truth.
I swear to tell the truth, the whole truth, and nothing but the truth.
Please proceed. What is your opinion as the court experts regarding the orthodontist's actions?
Your Honor, members of the court, the attending endodontist initiated calcium hydroxide therapy, an evidence-based approach to hold resorption. Subsequently, he utilized approved materials for root canal obturation and followed radiographic and clinical monitoring protocols. This specialist adhered to guidelines and mitigated further harm. My opinion is that he acted as indicated by current best standards of care.
Thank you. You are now excused.
Now we go on with the final expert witness, Dr. Leonardo Castellarin. Please approach the bench. Will you take an oath?
Yes.
A religious oath?
Yes.
A Christian religious oath?
Yes, according to my faith and beliefs.
Please put your right hand on the Holy Bible and repeat after me. I swear to tell the truth, the whole truth, and nothing but the truth.
I swear to tell the truth, the whole truth, and nothing but the truth.
Please proceed.
Your Honor, member of the court, as a board-certified expert in dental traumatology, I have reviewed available records, timelines, and clinical decisions in this case. My testimony will delineate the deviation from accepted standard of care, the consequences and parties responsible, while also acknowledging appropriate intervention by subsequent providers.
Dr. Leonardo, please explain to us, what is the standard of care for managing undental avulsion?
The immediate management of an avulsed tooth is time-sensitive. Optimal outcomes require implantation within 60 minutes after rinsing with sterile saline. If delayed, the tooth must be stored in a biocompatible medium, such as saline, cold milk, or specialized solutions, to preserve periodontal ligament viability. Dry storage such as gauze, reduces long-term survival to less than 30%. Standard protocols include stabilization with flexible splint for 2 weeks, antibiotic prophylaxis, tetanus assessment, radiographs, and photographic documentation. Follow-up care requires written instructions and adopting intervention within 7 to 10 days to prevent infection-driven resorption, and structured clinical radiographic evaluation at 2, 4, 8 weeks, 3 and 4 months, and annually for 5 years.
Could you please emphasize the deviation from the recommended protocols regarding the immediate management just after the injury in the basketball court?
One of the most important mistakes was the failure to reimplant or restore the teeth properly. The teeth were stored in a dry gauze for 3 hours, desiccating periodontal cells. These alone reduced tooth survival probability to less than 30%.
Were there any other deviation from the standard of care?
Yes, Your Honor. Mistakes in subsequent management further complicated the treatment outcomes. The use of a non-flexible splint is contraindicated in avulsion cases, and as it promotes ankylosis and resorption. Omission of critical steps, including no prescription of antibiotics, tetanus assessment, radiographs, or photographs. Moreover, no written instructions were given, failing to provide guidance for follow-up care abroad, leading to fragmented treatment.
Was there any negligence found for the orthodontist?
Yes, the splint remained for 2 months, exceeded the 2 weeks limit, exacerbating ankylosis risk. Although the orthodontist referred the patient to the pediatric dentist for further management, he failed to advocate for urgent care, since the parents did not clearly understand the urgency for care. Thus, he is held responsible for the delayed treatment, allowing resorption and infection to progress unchecked.
Did the pediatric dentist adhere to the standard of care?
The pediatric dentist commenced for proper history assessment and clinical and radiographic evaluation, removed the splint, and referred the patient to the endodontist for further treatment as best practices warrant.
Did the periodontist and endodontist adhere to the standards of care?
The endodontist follow radiographic and clinical protocols as advocated by current guidelines. The periodontist conducted a thorough periodontal evaluation, implementing a long-term monitor plan to track resorption and infraposition risks. In conclusion, these specialists adhered to guidelines and mitigated further harm. Their interventions, however, were necessitated solely by a prior mismanagement.
Thank you. You are now excused.
Now we go on with the final expert witness, Antonio Fadoul and Aliki Lembesopoulou, who will inform us for the adverse consequences of the timeline of events that took place after the incident and shed light to measures that could have been taken for their prevention.
Expert witness Dr. Antonio Fadoul, please approach the bench. Will you take an oath?
Yes.
A religious oath?
Yes, Your Honor.
A Christian religious oath?
Yes, in accordance with my faith and beliefs.
Please put your right hand on the Holy Bible and repeat after me. I swear to tell the truth, the whole truth, and nothing but the truth.
I swear to tell the truth, the whole truth, and nothing but the truth.
Please proceed. Dr. Fadoul, what in your opinion are the consequences of inadequate tournament organization?
Your Honor, as a member of the court's final expert witness, it is hard to turn a blind eye to the inadequate tournament organization and its unfortunate consequences. First and foremost, the clear absence of an immediate first dental aid kit. Moreover, 2 coaches, 3 physicians, and 2 physiotherapists all failed to reimplant the teeth immediately, as they ought to give the first dental aid. Plus, there was a lack of tooth storage media, such as a tooth-saving kit. On top of that, the access to the hospital services was ultimately delayed. Failure to properly manage the incident promptly, namely to implant the teeth immediately or store them in an appropriate storage medium and have a dentist reimplant them within 1 hour, reduce the tooth survival probability from a high of over 90% to a low of less than 30%. Also, there was a lack of mouthguard recommendation.
Can you elaborate more on this, Dr. Fadoul?
Yes. While basketball is notorious for having one of the highest incidence of sports-related injuries, the protective and positive results of wearing an athletic mouthguard cannot, and I repeat, cannot be understated. You don't have to take my word for it. This has been demonstrated in numerous studies, although its use, unfortunately, is not mandatory. However, both the team and the tournament organizers failed to advocate for any use of the mouthguard by the players. All of the above and what I just mentioned are a combination of unfortunate factors rather than a single root cause which can be attributed to inadequate tournament organization.
Thank you. You are now excused, Dr. Fadul.
Dr. Lebesopoulou, please approach the bench. Will you take an oath?
Yes.
A religious oath?
Your Honor, I will take a civil oath.
Please repeat after me. I solemnly declare on my honor and conscience
I solemnly declare on my own conscience
that I will tell the whole truth and nothing but the truth,
that I will tell the whole truth and nothing but the truth,
without adding or concealing anything.
without adding or concealing anything.
Proceed.
Your Honor, members of the court, the dentist at the hospital, although he reimplanted the teeth, which the recommended management, failed to use an appropriate splint, which may have accelerated root reabsorption and ankylosis. Furthermore, poor follow-up has reduced the chances for a favorable outcome, which could have been avoided had the hospital dentist given written instructions after the immediate management of the injury. Moreover, complex salvage procedures, prolonged treatment, and some substantial risk of tooth loss in the lifetime of the patient may enhance the financial and emotional burden. Were the emergency measures taken as indicated and within the recommended time frame, the likelihood of saving the teeth for a lifetime would be substantially higher. Instead, the patient now faces extraction and prosthetic replacement, outcomes directly attributable to the initial mismanagement.
Dr. Lebesopoulou, you clearly explained the short-term consequences. Dr. Fadul, can you please inform us on the long-term oral health consequences for the patient as well?
Yes. Well, dental trauma frequently affects the maxillary incisors, as these teeth are the most vulnerable to impact injuries. In severe cases, such as avulsion, endodontic treatment is often required. While literature suggests that these teeth may remain functional for many years post-treatment, they are ultimately lost due to progressive complications. One of the primary challenges associated with the extraction of these teeth is the presence of endodontic failure, often accompanied by root resorption, ankylosis, apical inflammation, or a combination of what I just mentioned. These conditions contribute to significant bone loss. Furthermore, the initial trauma itself compromises the periodontal ligament and reduces the buccal bone volume. The associated soft tissue frequently exhibits scarring and recession, further complicating the extraction process. Consequently, these extractions are often traumatic, resulting in additional bone and soft tissue loss.
Are there any other complications likely to occur?
While in cases involving young patients with incomplete facial growth, the long-term prognosis for avulsed teeth remain particularly poor. Over time, progressive bone resorption around the affected side is inevitable, leading to functional and aesthetic concerns. The loss of alveolar bone directly impacts lip support, altering the patient's facial profile and contributing to aesthetic disharmony. These changes can negatively affect self-esteem and social confidence, particularly in adolescents, who may experience significant emotional distress.
According to your professional opinion, how can these sequelae be managed, Dr. Fadul?
When dental implants are chosen as a restorative option, bone and soft tissue regeneration procedures are typically required before and sometimes even after implant placement. However, due to the complex interplay of unfavorable factors, including compromised alveolar bone, thin soft tissues, and scarred gingival architecture, guided bone and soft tissue regeneration may fail. This can lead to soft tissue recession, exposing the metallic component of the implant, which not only creates an aesthetic concern, but also increases the risk of peri-implantitis and subsequent bone loss around the implant and adjacent teeth. In many cases, implants must be placed in a more apical position to compensate for the reduced alveolar ridge. This results in the need for an extended prosthetic component to achieve proper occlusion. However, the discrepancy between the implant abutment position and the cemento-enamel junction of the adjacent teeth can accelerate bone loss around neighboring teeth, further exacerbating the problem.
Dr. Lebesopoulou, are there any further complications that may arise?
Your Honor, Ultimately, if peri-implant complications become severe, implant removal may be necessary. This leaves the patient with limited prosthetic options, such as Maryland bridge or a removable prosthesis. Thus, loss of an implant can be the final straw and could be psychologically devastating.
Can you give us your final concluding remarks?
I think most of us sitting here got a headache from listening to all what has been mentioned, so let's take a minute and imagine what such a patient could endure. What would happen to a patient who has already faced significant physical and emotional distress due to dental trauma and undergone multiple surgical interventions for their problem? This unfortunate reality is frequently observed by dentists and periodontists managing peri-implant complications, underscoring the challenges of restoring function and aesthetics in patients with a history of dental trauma. Your Honor, responsibility for this adverse outcome lies also with the tournament organizers and team that did not give the appropriate dental first aid and delayed taking the patient to the hospital. However, responsibility also lies with the emergency hospital dentist, whose negligence to give written instructions violated established trauma protocols. The orthodontist, endodontist, and periodontist acted appropriately within their scope, but their efforts could not reverse the damage inflicted during the critical early phases. This case underscores the importance of immediate protocol-driven care in the dental trauma for the training of all involved in the tournament to the dental first aid costumes and for the suggestions for mandating the use of athletic mouthguards. The failure to provide the above in this case constitutes a profound breach of duty, warranting accountability for the harm caused.
Thank you. You're now excused. Ms. Nicolaidou, please proceed to your closing statement for the plaintiff.
In light of the above, Your Honor, the plaintiff, a young boy full of promise, endured a traumatic experience that not only affected his physical health, but also left lasting emotional and psychological scars. This unfortunate incident occurred under circumstances that should have been prevented if proper safety protocols have been in place. The absence of the doctor at the start of the game, the referee's decision to proceed despite this absence, lack of first aid for the teeth, namely reimplantation, and the lack of tooth saver kit at the venue demonstrate a collectively failure to prioritize the well-being of the participants. Additionally, the lack of clear written post-operative instructions exacerbate the patient distress in hindered the timely follow-up care required for optimal recovery. It is the plaintiff's right to receive compensation for the pain and suffering he suffered, along with the cost for ongoing dental treatment and his emotional distress. Thank you for your attention.
Thank you.
Mr. Trabas, please proceed to your closing statement for the defendants.
Your Honor, esteemed members of the court, while the incident that led to the plaintiff's injury is undeniably regrettable, the defendants collectively acted within the scope of their responsibilities and available resources. The defendant players' actions were part of the natural flow of a competitive sports game, and there was no evidence of malicious intent. The referee's decision to start the game, albeit with the doctors present, was made in good faith to maintain the tournament schedule. The dentists involved, particularly the attending dentist in Rome, provided appropriate emergency care under challenging circumstances. Any shortcomings in the subsequent treatment pathway cannot be solely attributed to the actions of the defendants, but are rather a result of various interconnected factors, including the delay in follow-up care and the patient's relocation. The defendant requests that the court considers this faction in its judgment and recognizes their effort to act in the best interest of the patient given the circumstances. Thank you for hearing me.
Thank you. We now have to deliberate.
In the audience, you may now vote again.
Case
dismissed.
So, let's see, who do you vote as the most liable? Rank first. And the least liable, we have the fifth option here down here, for now. So let's see, it's moving, it's live. Okay. So judges, you will get the audience opinion. It looks like steady.
All right. So we are now at the last stage of today's event. I would like to thank all of the participants. Please give them an applause. I would like to thank the rector, the vice rectors, and the deans for their support, and all the staff of the European University Cyprus for their support. And I would like to thank also all the professors from both schools who made this happen. And I hope next year we will have even a bigger event. We could talk about all these issues for many hours or many days. It could be a great conference, maybe. And thank you all for being here today, participating and contributing to this event. Thank you.
I would also like to tell to our students that they exceeded all of our expectations. You were all exquisite tonight. Thank you. Okay.
Case dismissed.